Thank you, Deborah, for that introduction. Hi, everyone. Thank you for inviting me here today. I'm Samira Kermani with Kermani Law Firm in Los Angeles, and I'm going to be speaking to you briefly on risk management and its flip side, which is consumer protection. It's critical to manage your risks as broker owners, and in my opinion, there is no better way to do that than to know what the law actually says and requires of us as fiduciaries, what the definition of negligence is, for example, in your day-to-day dealings with clients, and what type of conduct is considered negligent or fraudulent. You simply cannot guard against a claim for breach of fiduciary duty or negligence if you don't know the simple definitions of those claims. Furthermore, I strongly believe that following the law and actually being a good fiduciary and protecting the consumer, protecting your clients, buyers and sellers, is actually good business. And we shouldn't look at it just as a way to avoid lawsuits or risk management, but also as a way to protect the consumer. And really, you're setting yourself apart from the crowd, and you are going to rise to the top of your field and going to be the best of the best. So, you know, we all talk about risk management as if we have to protect ourselves against lawsuits. What we really need to remember is the law actually requires of real estate agents and real estate brokers to put the interests of the client ahead of the interest of the agent. That's what the law requires. So that's what risk management is all about, protecting the client, the consumer, and putting their interests ahead of ours. So these best practices tips that I'll share briefly with you today are limited due to our time. Best practices tip number one is know your PMK. As the broker owner or the broker manager of your office, you may be the person most knowledgeable in your office, and you're going to know about the day-to-day operations of your business, the protocols and practices in your office. When a lawsuit is filed, plaintiff's counsel typically sets the deposition of the PMK. That's the person most knowledgeable in your office about your practices, your protocols. And so each office should have a PMK, and your attorney or counsel will help you identify that person. And you want to develop strategies to train and supervise your employees and your licensees' activities. You want to implement systems for documenting compliance with policies and protocols. You want to recognize and avoid illegal licensee activities and unethical practices. You want to develop systems that are going to alert you when there are new changes in the law or new DRE regulations that are changing. You want to become aware of those and incorporate those into your policy manual, which is the subject of our second tip. My best practices tip number one is it's important to have an office policy manual and to review it at least once a year with your counsel. I also recommend that you have your counsel revise it so that it reflects new changes in the law. That way you can ensure that when new laws are enacted, your office protocol and your checklists also reflect and incorporate those new changes in the law as well. It's a good idea to become familiar with the elements of a claim for breach of fiduciary duty and negligence. And what your counsel can do is, lawyers use we use jury instructions. So jury instructions set out the elements of claims. And what your counsel can do is take the jury instructions and make sure that your checklists marry them basically with your checklist and with your policy manual. Make sure that they're incorporated and that your entire office is in compliance. So obviously we don't expect agents to be familiar with jury instructions, but when you have nice little checklists or cheat sheets that they have when they're doing a transaction that's been approved by your counsel and counsel has taken into consideration jury instructions, then you're farther along the way in ensuring compliance. My third tip for best practices is confirmatory emails. That's another important risk management tool. I prefer to have all of your emails saved to PDF and training all your agents and transaction coordinators in the office to do that as well. I'll give you an example. Often in a lawsuit, a buyer will be shown a document and they'll say, gee, I've never seen this document before. So without a dated or timestamped fax transmittal, it's really hard to prove what document was delivered, what version of it was delivered, who was it sent to, who received it, on what date and what time, depending on what issues come up in the lawsuit. So what I like to advise my clients is when there's a critical time event or a critical meeting that you've had with a client, please create evidence of it. And there's, obviously you can have testimonial evidence, but it's much better to have the file speak for itself. So those of you guys who have transaction coordinators, and you don't send emails to your clients, you just have the transaction coordinator get all the disclosures and email them in one PDF batch to the buyer, for example, and say, here you go. It's going to be really a lot more challenging to prove what was in that PDF batch and whether any concerns or questions of your client were answered. So let's say, for example, you have a phone conversation with a buyer who received a TDS they have a question on, or a physical inspection report, and they have a question. Physical inspection report says you need to do a roof inspection. And your client says, what do you think? Obviously, if you've taken one of my risk management classes for agents, you know that you've had your seller designate their expert, choose their vendors, their roofers, and so forth ahead of time, so that when you're in a bind, short time frame like this, they don't have to start interviewing roofers. But in any case, you just send an email to your client and you say, hey, here's the physical inspection report. I highly recommend that you follow the advice of your physical inspector and get a roof inspection. Please let me know what your roofer says and when you'd like to schedule it. I'll contact the listing agent, make an appointment for us. And this way, you've done several things. You have created evidence that you advise the client. You can CC your manager, CC escrow if you have no one else to CC. If the client doesn't reply, you forward the same email. You say, hey, I'm just following up. Obviously, you're going to pick up the phone. You're going to call your client. You're going to have a conversation with them. But don't just have an amazing conversation and not document it in the file, is my point. Confirmatory emails go a long way toward settling a dispute in a case where, let's say the buyer says, you never really told me the importance of a roof inspection. And, let's say you did, and you really went a long way towards helping them schedule the appointment. So I would like to have evidence of that in your file. And no, it's not good enough to have, I know some people say, what about if the client fills out that form, the CAR form, opting out of inspections, and the client says, I'm opting out of the following inspections, and you're like, they opted out. That is absolutely does me no good, depending on what the lawsuit is about. If you're being sued for conduct falling below standard of care, which is breach of fiduciary duty, it does me no good to have a sheet of paper that says they opted out, they did not do the roof inspection. Because obviously we're here because they didn't do a roof inspection. We all know they didn't, and that's part of the lawsuit. What I need is the fact that you advised them and you recommended and they went against your professional advice. Okay, so that's an example of confirmatory emails, why they're really important. Best practices tip number 4 is you write it, you defend it. Another problem I see often in my law practice is agents coming in or buyers and sellers coming in, and there's a dispute as to a paragraph or provision or a sentence in a contract, an addendum, sometimes even in disclosures, addendums to TDS. And I read the paragraph and I have no clue what they're saying. I have no idea what they mean. You show it to a colleague and they have 2 different opinions. So anytime you write something where 2 different people can read the same paragraph and have 2 opinions, or sometimes I can have 2 different opinions about the same paragraph, you're asking for trouble. It's just asking for a lawsuit, asking for a dispute. So the tip is, the risk management tool is, if you're trying to draft something and it's complicated and it's a long paragraph and you're not exactly sure how to put it, and sometimes, agents are really sure that what they're saying is very clear. So run it by someone else, show it to your manager. If it's really complicated, have your attorney or your general counsel draft it for you. Put it on them, put the liability on the lawyer. At my law firm, we have a rule. You write it, you defend it. Nobody writes a sentence who is not prepared to go to court and defend that sentence. Until you have been in arbitration or trial over the interpretation of a sentence in the CAR forms, you won't really appreciate what I'm trying to tell you. So, they say if you cook it, you eat it. If you write it, you defend it. If you're not prepared to defend it, and it's a complicated paragraph, don't write it. Don't take the risk. Run it by a manager. My best practices tip number 5 is custom disclosures. So I have successfully avoided claims for many of my clients by creating custom disclosures. When does that come in? Let's say it could be anything from a remodeled home where there's a lot of permits that are being questioned, there's square footage that doesn't match, or there's been a past dispute with a neighbor that they found out about, or in a commercial shopping center deal, the cap rate doesn't match the income stated in tenant estoppels or the triple net or what have you. Typically, you're going to have the buyer ask a question, or sometimes when you even notice a discrepancy. What you want to do is you want to take that question, let's say it's an email from the buyer or the buyer's agent, and they say, we noted this discrepancy, or my client reviewed the disclosures, has this question, and you reply back, you say, thank you so much. I will submit this question to my seller, find out his or her answer, and get back to you. So what you do is you forward that to the seller, and you say, they have these questions, please advise and let me know. And it's fine if this is done over the phone. Just make sure that you say, let me make sure I understand your answers correctly. Is this what you're saying? Thank you so much. I'm just making sure that I get it right, and that it meets with your approval. So I'm going to prepare, let's say you're talking to your client, the seller, and hopefully you're not a dual agent in this case, or ever. You say to your seller client, I'm going to prepare a disclosure because this is a material fact, and it'll just be on our firm letterhead, and it's going to be signed off by you and the buyer, and it's for everyone's protection. That way the buyer acknowledges receipt and knowledge and approves it, right, when they lift their contingencies. So that's the long and short of it. You take that disclosure that your seller client has signed off on, you submit it to the buyer, make sure they sign off on it as well, and you can CC escrow, you can CC several people. You want to create a record that representations were made that came from your client. Don't ever say, oh, I know why the income is not matching or this and that. Even if I would much rather you don't make that representation, because you're not the owner of the property. The seller needs to make that representation. And if the seller is not willing to make that representation in writing, then that's a red flag, and you need to have a conversation with your manager. They'll have a conversation with counsel if needed. But in any case, hoping that this was helpful. These are my top 5 risk management tips for broker owners. If you have any further questions, you can reach us 310-475-3400. Thank you.